All right, I am pleased to start the hearing for Kimberly Moses Smith. And to start that off, I want to read the letter that we received from Governor Baker, dated September 23rd. I am pleased to nominate Kimberly Moses Smith to the position of Associate Justice of the Probate and Family Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing a nominee's resume for your convenience. Sincerely, Charles D. Baker, Governor. So welcome, Ms. Moses Smith.
Thank you very much, Councilor
Let me introduce the councilors that are here. Councilor Jubenville to my right, Councilor Iannella.
Good afternoon.
Councilor Kennedy. And would you like to introduce your guests? Councilor Hurley. I'm sorry, Councilor Hurley on the screen over there. Hi, Councilor Hurley. And Councilor Duff may come back. She had a doctor's appointment, but may come back by Zoom. Is she on? Councilor Duff is on as well. Well, she's, okay. We can't see her, but hi, Councilor Duff.
Hi.
Unmute, please. Certainly.
Would you like to introduce your family and guests?
Certainly. Here with me today is Gina DeRossi. She is the Court Administrator of the Appeals Court. My son, Owen, my daughter, Claire, and my father, who is a retired judge, Richard Moses of the Superior Court.
No.
Excuse me.
Councilor Hurley, we can hear you about talking to your dog.
Oh, was that Councilor Jubenville you were talking to?
I also want to introduce Councilor Marilyn Devaney Petito, who just walked in.
It's Marilyn Petito Devaney. Nice to see you.
I thought that's what I said. All right. Anyway, we're going to start with your witnesses. I know you brought one witness live and one witness by Zoom, I understand?
Yes, I have
Okay.
a witness.
So we're going to have Gina DeRossi, who hails all the way from Bristol County, former Register of Probate, now Court Administrator for the Appeals Court. Please give your summation. Nice to have you.
Thank you very much. Thank you, councilors, for the opportunity to speak this afternoon on behalf of Attorney Kimberly Moses Smith. When Kim asked me to speak for her this afternoon at this hearing, my first reaction after immediately saying yes was to ask her in what capacity. You see, I've known Kim for over 2 decades, and our connections have been, well, numerous to say the least. I'm proud to call her my friend after all these years, but we actually met as opposing counsel and fellow family law attorneys many years ago practicing in the streets of New Bedford, I like to say. Our connections only grew over the years, and with that, so did my deep knowledge and understanding of Kim as both a lawyer and a person. I can say with confidence that I know Kimberly Moses Smith. I know the person she is, I know the lawyer she is, and most importantly, I look forward to sharing with you this afternoon the kind of judge that I know Kimberly Moses Smith will be. Kim and I grew up in the trenches of the Probate and Family Court, and yes, those of us that practice there like to call it the trenches, because that's exactly what it is. Kim has always stood out among her peers as someone who is balanced, likable, very likable, fair, and able to be a zealous advocate for her clients while maintaining respect for the process, the court, and especially opposing lawyers and litigants. This is not an easy feat, and quite frankly, something often missing, particularly among some, even many domestic relations lawyers. Those that practice in the area or have been to the court probably have witnessed that on occasion or two. While I had known Kim most as a colleague working in the family court, our connection wasn't limited to that. We also worked together on the New Bedford Bar Council for many years. Most recently, I served as the vice president to her presidency. I've watched her lead, organize, and educate. She represented our legal community with distinction. But today, I'm here in my capacity as the former Bristol County Register of Probate. I served there for over a decade until my appointment as court administrator in late 2018 to the Mass Appeals Court. During my time as register, Kim Smith was a fixture in the courtrooms, the hallways, the staircases, the registries in Taunton, New Bedford, and Fall River. And just like a magic trick, sometimes at all 3 places on one day. In addition to her almost daily presence in our court, the buildings, the offices, she was one of our most consistent Lawyer of the Day volunteers and was often tapped to serve on continuing education panels that highlighted trends and changes in both probate and domestic law and procedure. I, along with my court staff, had the pleasure of working with Kim and observing firsthand her commitment to her clients and the law. I have watched her, literally have watched her for hours, zealously advocate for her clients in custody, support, divorce, guardianship, and estate cases. Some of these cases contentious because her clients were, let's say, difficult. Some were contentious because opposing lawyers were difficult. Some were just difficult cases, tough facts, tough law, and dare I say, sometimes the judges were difficult. Whatever the circumstances, what never changed was Kim's approach. Her approach to the judges, to the clerks, to the court officers, to the secretaries, even to the litigants on both sides of the case. She consistently showed an unwavering respect for the work of the court. Kim understands the unique and difficult business of the probate and family court. She's practiced for years in other courts. Her experience isn't just limited to the probate and family court. And because of that, she understands the unique challenges of this particular court. She's also seen as a mentor for the younger, sorry, Kim, less experienced lawyers in the probate and family court. She's got a natural way of guiding lawyers through the system, through the process. That includes those who are serving as opposing counsel. She's got a respectful demeanor with a broad understanding of the nuances, not just of the law, but of protocol and procedure. Kimberly Moses Smith has no ego. She has no airs about her. It makes her approachable. It makes her real. It's just one more reason why she's so universally admired by and respected by peers, court staff, and judges. I cannot overstate my support for Attorney Smith's nomination. She would be an asset to the judiciary of this Commonwealth, and in particular, to the probate court bench. She has the requisite combination of proficiency and humility to imbue her with the judicial temperament necessary to be a successful, effective justice. Thank you for your time.
Thank you, Attorney DeRossi. Any questions? Counsel Jubenville?
Nice to see you.
Nice to see you too, Counselor
And I'm so
Jubenville.
glad that you got elected to the probate.
Thank
You know
you.
why?
Why?
You think it's because I wanted you to win. It was to get you out of campaigning. You know why?
Why is that?
Every event we went to, you spoke first, and all the committee members were in awe, and they watched you walk out. I'd speak, they weren't even paying attention to me.
Oh, I'm sorry.
We gotta get this woman elected, so get the hell out of these committees. But it's great to see you, and we had a lot of fun.
We absolutely did.
Yeah, we did.
And I'm glad you finally made your way here.
Yeah, well, I don't learn my lesson. I keep trying.
Thank you very much for your testimony, for coming all the way from Bristol County. Next, I believe we have someone joined us from Zoom.
Yes.
And that would be David Requena. David, are you there? I see a DR on the screen. Hi, David. Welcome to our assembly. We can't see you, but we can hear you. Can you hear me, David?
I'm here.
Now we can see you.
All right.
Well, thank you for offering to testify on behalf. And the floor is yours.
Okay, good afternoon, everyone. My name is David Requena. I'm here to speak as a client and also as a friend of Kim Smith. I met Kim a few years back in probably one of the hardest times of my life. And going through a process that I thought was going to be the hardest process I ever had to deal with, Kim made it as easy as she possibly could. There were times in my divorce that I felt like I wanted things to get a little bit more adversarial because of things that were happening, and Kim never allowed that to happen at any point. We had instances with my daughter, who is now 12, soon to be 13. She was 9 at the time. It was a hard process for her, a hard process for us, and she's come through this as well as she possibly could have. She's made all the adjustments. Her mom and I are co-parenting. Kim assisted us with getting all of the right wording, verbiage into our agreement, and that has helped us tremendously, both in moving forward and as well as in the handling of our daughter. I couldn't think of a better nominee for a judge in your court. Kim has always been very honest, respectable, and she has always upheld the highest integrity throughout our whole process, and I'm honored to speak on her behalf.
Well, thank you. Thank you very much. Your testimony means a lot, and it's I think an anomaly when somebody comes in and says they're happy after a divorce, because like mediations, as the judge is here, he does mediations now. We call it successful mediation when both sides walk away unhappy, thinking they both got screwed. So it's good to see someone that went through the probate court process thinking that they get the best deal they could get, and I'm glad things are working out. I'm a divorced dad. I had shared physical custody, and I can tell you co-parenting worked perfectly, and that's what I'm looking for in a judge, is somebody who supports what you and I went through, that we can co-parent and have good existence going forward.
Absolutely, I agree.
Any other questions for David and the councilors?
No.
Okay, thank you so much.
Your testimony.
Excellent, thank you.
Thank
Oh, I'm
very
sorry,
much.
Council Devaney said you're. Go ahead,
I
Council.
just wanted to say your testimony means a lot, and I know it must mean a lot to the nominee. Thank you very much.
Thank you, David.
Thank you. Have a great evening.
Thank you, you too. Is there anyone else here on behalf of the nominee? Want to open the door for those opposed to the nominee? Anyone lined up outside there? All right, we're going to end that part of the hearing. And now we're going to hear from you, why we should say yes to you becoming a judge.
Well, thank you. First, I want to be sure to thank a few people, and I'll be short and sweet, I promise. Obviously, I want to thank you all, the Governor's Council, for considering me for this position, and especially Councilor Ferriera for all his help in navigating this process the last few weeks. I'd also like to thank Governor Baker and Lieutenant Governor Polito for their faith in my qualifications to nominate me for this position. I would be remiss if I didn't thank Bob Ross and Lauren Green for all their help and kindness and support throughout this process, as well as the members of the Judicial Nominating Committee. I'd like to thank my witness via Zoom and here in person today for coming today and speaking for me on my behalf. I'd like to thank my law partners, John Markey and Tim Walsh. Not only do they make me and challenge me to be a better lawyer every day, they also challenge me to be a better person every day. And of course, I'd be remiss if I didn't thank my friends and family who supported me throughout this process, my parents, my step-parents, but most importantly, my son and my daughter, Owen and Claire, who have endured many nights of me working at the dining room table, preparing for trials, going to the office on the weekend. And I think this means as much to them as it does to me. They're my rocks. Although I was born in Newton, I resided my entire life in Bristol County. Growing up, my parents always impressed upon me not only the importance of education, but also the value of hard work. Both of my parents were in the first generations of their families to attend college. My mother's father served in the Navy during World War II and later worked in the Naval Yard in Charleston. My father's father owned gas stations in Chinatown and later outside Fenway Park. While it was always understood that my sister and I would get an education, we were always reminded that the hardworking, less educated person was certainly no less respected than those with a higher education. My parents separated and divorced when I was 8 years old. To say that they were ahead of the curve in terms of co-parenting would be an understatement. My sister and I always came first and never felt otherwise. Despite the demands of my father's busy law practice, we saw our father every other day and every weekend without fail. My mother was exceptionally understanding and accepting of that role in a time and a climate which could have dictated otherwise. As a young child, I spent many afternoons in my father's law office while my mom was working. While I was supposed to be doing my homework, my attention was always drawn to watching my father work, helping clients, providing advice on a myriad of issues. As I grew older, after hearing about the cases he handled and the people he had helped over the years, I realized not only the tremendous responsibility of being someone's advocate, but also the honor in a client choosing you to serve that role. After attending law school, I was fortunate enough to have a space waiting for me at my father's office in New Bedford. He was a true general practitioner handling everything, including civil litigation, criminal defense, probate, and domestic relations matters. After spending the first few years of my practice in the district court, my father one day walked into my office and said, "You're going to handle all the family law cases from now on. I think you have the temperament." While I still joke with him good-naturedly that he pulled one over on me, I quickly grew to appreciate and enjoy the practice of family and probate law. That was truly the moment I began to appreciate the tremendous responsibility being a probate and family attorney brings. While other attorneys may look at probate court practice with disdain, I have always found it an honor to be chosen to represent and advocate for someone dealing with their most personal issues at the most stressful times in their lives. I was fortunate to practice with my father for 6 years before he took the bench in the Superior Court. And facing the numerous challenges and frustrations being a probate court practitioner can bring, I was always reminded of the importance of maintaining civility with my colleagues and in the courtroom, a lesson I carry with me to this day. Probate court is unique in that the majority of litigants continue to have interaction with one another long after a judgment enters. While as an attorney, we are supposed to zealously advocate for our client, I have always felt as a probate court attorney, we also have an obligation to not unnecessarily inflame matters. For the most part, probate court is not a court of wins or losses. It's about helping families reach a result that works best for them. Throughout my many years of practice, there has been no greater compliment to me than the client who thanks me for making the process so much less painful than it could have been. It has truly been an honor to assist people in this capacity for the past 24 years, and if confirmed, I'm hoping I will continue to do so from the bench for many years to come. Thank you.
Thank you. A couple of councilors are asked to go first because they have appointments, medical and other things. So Councilor Jubenville?
I have a court Zoom here, but I don't have any questions for you. I'm glad that there's going to be a Moses back on the bench. Your father was a great judge and well respected. Nothing but good words from
Oh, thank
people
you.
that came before him. And your Uncle John was such a wonderful guy. I had such great memories of John. He was so unassuming as a lawyer that a lot of lawyers that were defense lawyers that had trials with him didn't understand that he was not unassuming, but when he wanted to, he could really, really surprise you with the way he said things and did things in court. But I enjoyed him very much, and I saw him quite a bit after he got out of the DA's office. And we talked for many, many times about different cases we had, but I really loved him. And I think you're going to make a wonderful judge.
Thank you.
Thank you, Councilor Jubenville. Councilor Duff? Councilor Duff, are you on? You asked me to go over there. Says ED. I assume that's Eileen Duff. She doesn't appear to be on? Okay. Councilor Iannella?
Thank you very much. Just, first of all, it's good to see your father. I believe I was here when he was confirmed many years ago. I remember in those days, I haven't talked to these folks in a long time, but there's a law firm in New Bedford, it's been a while. Hamill, Waxler, Allen, they thought a lot of your father. And again, I never appeared in front of him, but you've had a distinguished career, and it's good to see you. Parenting plan, co-parenting. I'm a strong advocate of children's rights. Tell me your thoughts of what does parenting plan mean to you, or co-parenting? What does that mean to you?
Every circumstance in the probate court cases are very fact specific. But in terms of co-parenting, it would be equal sharing in parenting time, decision making, and those types of matters.
So when you say equal sharing, to me, equal sharing means 50-50. Again, I've handled one probate matter, divorce in my life, okay? So you know this obviously a lot better than me. When you say equal sharing or equal parenting, does that mean 50-50 to you? Because that's what equal means to me.
It doesn't necessarily have to be equal down to the hour, day, minute. I have many people who I've represented that have a shared parenting plan that may be a 4-day, 3-day schedule. I think substantially equal would be the
Okay,
best way
so
to describe it.
If somebody had an arrangement of every other weekend, say Friday night, bring back the children, Sunday afternoon, and every other Wednesday, would you consider that an equal parenting plan?
That would not be, in my opinion, equal.
And even if it was agreed upon, okay, and obviously I assume you'd adopt it because it's agreed upon, but would you still not consider it an equal co-parenting plan?
If it's, we're trying to get generally away from labels in the probate court anyways,
But
because
I'm
they tend to
old-fashioned.
be
I've
divisive.
been around a long time. So would you consider that? If you had to put a label on it, someone, the hypothetical I just said, was agreed upon by both parties, would you consider that an equal parenting plan?
It would not be equal in terms of time if they want to consider it.
I understand that, but would you? If someone said, hey, the Smiths, I just saw the Smiths plan, would you consider that an equal parenting plan?
I wouldn't even know that I'd need to put a label on
But
it.
if you had to put
Oftentimes,
a label on it.
typically, we don't need to put a label on it unless it's for school purposes. If I had to put a label on it, I would not consider that an equal
Okay.
parenting plan.
So let me ask this question. Fall, New Bedford, right? I don't even know. How far away is New Bedford from Fall River?
15 minutes.
Okay. What's 35 minutes away, 40 minutes away? I don't even know.
Seekonk.
Seekonk from New Bedford? Okay. So let's assume you had 2 children, minors, great parents, whatever great means to you. Parents are both lawyers. The kids live in, well, the one parent lives in Seekonk and the other lives in New Bedford. And it's contentious. They both want the children with them 100% of the time. Assume everything is like, wow, these people are great. Is that something that you would, again, best interest of the children, is that something that you would consider as close to 50-50 as you understand where I'm coming from? Or like, oh, that's 40 minutes away. These kids are 8 years old and 6 years old. It's not realistic.
I think it is something I could consider if the parties are willing to share in the transportation, minimize transitions during the school week for the children, and
Say that
all
again,
other
I didn't
things,
hear the last part.
and minimize transitions during the week for the children.
What does that mean? I'm not sure.
So they're not, take for instance, they're not saying, okay, I'm going to have the children Monday, you're going to have them Tuesday, I'm going to have them Wednesday. It would need to be chunks of time during the week so the children aren't.
No, I like that, but tell me more specifically, what would that mean? Like Monday, Tuesday, Wednesday with this parent, Thursday, Friday, Saturday, like, what do you,
I've had a lot of success with
again,
schedules.
I'm sorry to interrupt you,
That's okay.
but I'm talking about where it's contentious, it's not agreed upon. Obviously, if it's agreed upon, it's an easy question. So, and I'm sorry to have interrupted.
With all other things being equal, it is something I would consider. I've had a lot of success with people doing shared parenting where one party has the children Monday, Tuesday, the other party has the children Wednesday, Thursday, and then they alternate Friday, Saturday, and Sunday. So it does help to minimize transitions during the school week for children and also affords both parties a nice chunk of time when they have their parenting time on the weekends as well.
And what would be considered, I like the answer, by the way, because I think way back when, I remember I grew up in Jamaica Plain. In those days, the father would be working and the mothers would stay home. Things are totally different now. So I like that answer because I'm a big advocate of that. I think children should have equal access to both parents. At some point, it becomes unrealistic. In other words, what I know this is a tough question, but like 35 minutes, you consider that. Obviously, if it's how far, it just keep it down. If the both parents live an hour away, it's unrealistic, and at some point, it's too far.
I would agree. I think it's difficult to say now with remote learning because that can be done from
Well,
either
forget the
parent's
remote,
home.
that's temporary, hopefully,
Um,
hopefully.
Hopefully, yes.
Yeah.
But I would say probably an hour, but there are ways to make up for that in the summers and providing, having a summer schedule versus a school schedule and so forth.
I like that answer a lot, because like I said, I don't like the fact that either parent would have, under the initial hypothetical that I said, every other week, every other weekend, and every Wednesday, whoever the parent is. I just think that's awful. It's just not fair to the kids. But that's good. Pensions. Well, let me back it up. Your practice primarily now is divorce.
Yes, I do a fair amount of estate work, but primarily divorce modifications.
And I'll ask you the
contempt.
bonus question. I'm going to ask you the bonus question now. I think only one person has ever answered the bonus question correctly, so don't feel bad.
Okay.
Okay, it's just like, just having fun. It's late in the afternoon. So, do you know what a public administrator is?
I was actually a
She
public
was one.
administrator.
Oh, that's awesome.
So I do.
Bonus question. Oh, that's awesome.
So now you have
got
two
me.
people
I
answer it
love
correctly.
And I looked at that resume. It said it on here.
Yeah,
Yes.
it's on there.
I guess I'm not in detail as the
Being,
last.
you win, winner,
You
chicken
win
dinner.
that one. What do we give for winning that? I was a public administrator for 25 years. I haven't done one in a while. Oh, that's good.
Yes.
How'd you like it?
I enjoyed it.
Yeah.
I did enjoy it.
Did you get many cases?
I've probably had 12 over 8 years.
Okay. Well, that depends what the,
Depends
Yeah.
what they are, of course.
okay, that's good. Then I have a question about a pension.
Mhm.
Like us folks here, it's good, that last one, I liked it. Once we retire, depending on how many years of service, we're eligible for a state pension. Let's assume I elected, or anybody who has a pension elected option C. And option C basically protects the spouse. So the participant would get less now, okay? And the non-participant would be able to get survivor benefits. You follow me on that?
Yes.
My first question is, do you consider the pension an asset subject to division? Or do you consider it as a stream of income and you deal with it under alimony? Do you follow my question?
Yes.
Okay.
You're saying in terms of a divorce,
Yes.
and
yes.
they're not collecting it?
No, they are. They're in payout status.
You can divide a pension that is in payout status. However, it would depend on what the parties are looking to do. You can consider it, if you're going to divide it out, you can't consider it again as income.
So you would consider one or the other?
Yes, I wouldn't
Okay,
consider both.
that's good. I asked Judge Mennel the same thing. I don't know, he's a retired judge. He said the same thing. But again, it's contentious. What would you consider? Either an asset subject to division, okay, or a stream of income and under alimony. And you can say, hey, I have no clue. I appreciate that if you can do that. But your thoughts on that?
I think I'd have to look at the totality of the case, what other assets these parties had,
But
whether
why
they
would
had
that make
additional
Why
income.
would that make a difference?
It may
it's
make a
either-
difference in terms of just, if, well, I would think ease of convenience in terms of having a clear division for these parties, if it's in
But
pay.
if someone has an asset, someone has a bank account. I mean, it's either an asset or it isn't an asset. So I don't think, well, I don't want to say what I think. So you think it could be either or?
Yes,
Okay.
it could be divided.
But if it's not agreed upon, you could say, hey, but if it's divided, you would consider it an asset subject to division.
Correct, if it's divided. Otherwise, it would
But
be
that's what I'm
treated.
saying. You would, that's one option you think you would have as a judge.
Yes,
And in that situation, with a participant, elected option C, so the participant is taking less now, correct? Because he's protecting, or she
yes.
is protecting the spouse because of survivor benefits. Let's assume it's considered an asset subject to division. Would you give the participant, usually in a divorce, my understanding, like I said, there's one, usually it's a 50-50. You got a bank account, $100, 50 you, 50 you. where the participant in my hypothetical is taking less, okay, because he wants to give the non-participant survivor benefits. Under that scenario, would you give, it seems that would be, well, you tell me, how would you give the breakdown? 50-50? Or would you say, well, the participant's taking a hit now, I'll have to give him or she 58%, 60%. You follow my question?
Yes.
What would you do?
I certainly don't get involved in drafting qualified domestic relations orders, but
Well, you have to make a decision on the
Correct.
pension.
But my understanding is that you could allocate the cost, so basically the reduction 50-50 between the parties, so that it's an equal distribution upon once the pension is divided.
I'm not
So I
sure.
think you would need to make an allocation for that, yes.
So, okay, so if it's in payout status, and you've considered it an asset subject to division, you would not give it 50-50. You would not divide, because now you
I
got,
think what you're saying is, I would agree, I would need to be taken into consideration.
and you would give something less than 50-50.
Under those circumstances, I believe I would.
Okay, on the same token, let's assume you considered it a stream of income. And now it's, forget, like you said, and I agree, you can't do both. Now it's a stream of income, and again, the participant is taking less, okay, because the participant wants to provide the non-participant with survivor benefits. Under that same scenario, these days, everyone tells me alimony at 23, 28, let's assume it's 25%, you know. Would you do would be the same answer with respect to as if it was an asset? In other words, if you considered it a stream of income, you wouldn't give it like 25% to the non-participant. You may, under that scenario, only allocate 22%, 21%. Basically the same analogy as if it was an asset, because the participant's taking a hit. The participant is taking less now to provide more for the non-participant in the future.
I think if I was treating it in terms of income and making an order relative to alimony, I would just take the numbers as they come.
So you would not take into consideration that the participant is taking a hit now to provide more for the non-participant when the participant dies? Because the participant easily could have taken, I think, don't hold me, I think it's option A. Then the participant wouldn't be protected, the spouse.
I would be inclined to rule on the numbers as presented.
So you would consider that no different than someone's salary is 20,000, 50,000, I'm going to give 25% in alimony. The pension, same thing, 25%. So a little different both answers. Am I right?
Yes, if I were treating it as income, that's what I
If
would
you're
do.
treating it like income, it's just like regular alimony, no different, 25%. If it was a division of assets, you would give a little more to the participant.
Yes.
And here's a last question, I think. If you had to make a decision, how do you determine in other words, no one agrees. Is it an asset or is it the stream of income? What way do you go on that?
That's a good question.
That's what I'm asking. You
It's
follow me?
hard
In
to
other words,
say.
you
I
have
mean,
to,
that's,
because there's one lawyer saying this, it's an asset subject to division. The other one says, no, it's a stream of income. But now, here it is, you just heard the trial. What do you do in that situation?
I certainly think it would depend on the evidence presented to me. I would want to see what the numbers would look like if it was divided as an asset and when the parties go to collect on it, and what the numbers look like versus in terms of a stream of income.
But why should that make a difference? It's either, I don't understand why that would make a difference. What if someone has got, I don't care, $500,000 in the bank, and under one scenario, and the other scenario, that the participant's got 10,000 in the bank? I don't understand why that
Well,
would make.
this may be these parties' only asset, so.
What's that?
It may be their only asset.
Well, let's
So
assume.
I would want to see
let's
the
assume
effects
it's-
on.
Let's assume it's not their only assets. There's plenty of assets to go around. What would you do under that scenario? It's not an asset, they got plenty of money.
If they were presently collecting it, I'd be inclined to leave it alone and treat it as stream of income.
Okay.
was your last question, wasn't
Yeah, I think so. It's getting late. Good to see you.
Good to
I
see
know
you.
Councilor Ferrara, great supporter of yours. Seems like you have I haven't talked to you often, but nice temperament. I'm impressed with
thank
your
you.
temperament. Excuse me, sitting there. And Ferrara's a supporter of yours. You can count on me next week.
Thank you.
Thank you.
it? Thank you, Councilor Iannella. I know Councilor Kennedy has to run to a meeting. Go ahead, Councilor Kennedy.
I don't have a lot of questions for you. We had a nice talk on the phone. We had a nice conversation outside. I don't practice in the probate court. I went in there a couple of times when I was a young lawyer and got terrified, so I figured that was not a good place for me. I'm glad to see your father here. He's very proud of you, obviously. And, your two kids, they have a lot to be proud of. It's a great day for you, and I'll be voting for you.
Thank you.
Thank you, Councilor Kennedy. Councilor Hurley.
Can you hear me?
We can hear you now, yes.
Okay. We had a lengthy conversation. I reviewed your application and your resume, and I did a lot of practicing in the domestic relations field. And I think we had probably a similar philosophy. I used to tell my clients that you're not my only client. Your kids are my client too. Because how you deal with this divorce, something your kids are going to deal with for the rest of their life, and you're going to deal with the rest of your life. And when I had a client who was just out for vengeance, I would just say, look, you're doing something that's extremely harmful to your kids. And we talked about, the importance of shared custody and getting along for the benefit of the kids. So a lot of different things work for different people who work on different shifts. Mom works days, dad works nights. All those kinds of things, when they're taken into consideration, the bottom line is and always should be what's good for the kids. So I think you've got a great demeanor. You've got a tremendous amount of experience. And I like it when people say, I have to know the facts of the case before I can tell you what I would do. Because each case is different, and each case has to be treated separately. There are no hard and fast rules, especially in probate. It's so specific, fact-driven. It's really amazing. Your home counselor is very supportive of you, and I think I told you when we talked, I liked what you had to say. I liked your resume. I liked your application, and I'll be voting for you. So thank you.
These went out of business, So congratulations on your appointment. I'd like to I always ask the process of how you got here. So tell me when you applied and when the JNC, when you went before the JNC.
I applied in August of 2019 and yes, 2019, and went before the JNC in early October of that year.
And how many, we have 21 that are appointed by the governor for the Judicial Nominating Commission. And how many of them were there at your hearing?
I believe it was 12 during my hearing.
So 9 voted for a lifetime position, never saw you, never met you. And I don't say it to you, I say it all the time, it's wrong. That's an awesome responsibility that we don't have. But I just want to say hello to your father. I was so proud to vote for you. You know what the sad thing is? When you're here 21 years, the great judges that you vote on retire. I mean, that's a sad thing that I say. If we don't change that 70, I keep saying it. I can't do it, but someone has to do it. It's crazy. But anyway, what I want to tell you is, and I'm very proud, I'm a member of Women in Leadership for Shared Parenting, and it's growing. We've got hundreds of people outside the United States that are part of us, part of the membership. So it is important. I mean, there's no question today that you need two parents, and we still haven't come far enough for the fathers. We've come some way, but not enough, I think. But the shared parenting is great. So tell me, I'm going to tell you, this is true. I told you I was going to tell you this story, and I wasn't going to tell you when I met with you. Counselor Iannella and I were the only ones. It might have been 18, 19 years ago. We had a judge. And, you know, we don't have a crystal ball. You don't know what that judge will do. Sometimes a robe changes someone. Well, I picked up the Globe, and this was Boston Globe, must have been maybe a year after she had been on. And there was a young woman, mother, who had 3 toddlers, and she asked to move to Oregon with her 3 children. She didn't have family there. She didn't have a job. She didn't have a friend, and that's where she was moving. And I did my investigation. The father was so loving. He lived very close to them. He saw them almost every day, and he would stay over the night before Christmas so that he'd be there in the morning when they got up with their gifts. And you know, to me, it was vindictive. I mean, there is no way. I mean, that father will have no relationship with those children. And I hate the word visitation. I was just saying it to Counselor Ferriera. But she gave him visitation rights 1 hour on the internet. You can't hug a computer. And I thought, what a shame. So tell me, what criteria do you use to allow a removal?
Removal cases are probably one of the most challenging we have presented to us in probate court. It's a 2-pronged test. It's whether the parent seeking to remove can demonstrate a real advantage, such as, you know, job opportunities, family in the area, factors such as that, as well as a best interest of the children standard needs to be applied as well.
No, it's, well, we talked about removal when we met, and I love your writing. And that was a removal case, and they weren't married, but the mother of the child had been all kinds of drugs and alcohol. And I think that was the right thing, that he was allowed to go to Vermont and bring up the child. And, you know, in all the time we talked about that case, I didn't ask you, how did that child do? Because with alcohol and drugs, you know what happens to a child. I have a friend, and his child, she drank every day, and it's so sad. You know, does the baby have any of those, small head and all of those
No,
things?
no,
Yeah.
she's flourishing.
Yeah, she was all right.
Yes.
Okay, that's great. So restraining orders. How do you determine as a judge if someone is fabricating, if it really isn't true and it's just a disgruntled wife or husband making it up? How would you know?
I think you just need to listen to the testimony of the parties and assess their credibility to the best of our abilities. It's a difficult hearing, and there are occasions where I'm sure people do use them to gain an advantage.
That's the reason I ran for governor's council, because of that. I had a friend that was in a very dangerous situation with this guy, and I don't know why she ever got involved with him. We knew he was a bad guy. So anyway, she had a restraining order, and she'd gone to court 7 times trying to seek some help from the judge, and she wasn't getting any. So we had a police officer that was a friend, and he went with her, and he said to the judge, she fears for her life. Give him a $200,000 bail. He got a $200 bail. So in fear, she paid it. And he was out the door before my police officer friend, he told me. And the judge turned to her and said, you're wasting my time, and you're wasting this court's time. And 2 weeks later, she was dead. He killed her. And I didn't know governor's council. I never on the ballot as counselor. And I didn't know how judges got their job. I'm very ignorant. I didn't know. So I found out. And I found out what governor's council would do. And I said, there'll never be a judge like that. I don't have a crystal ball. Well, see, that's the problem, so we do the best we can. So, so tell me, what was the most, we talked about custody cases, and in this society, we see so many grandparents taking over custody cases. Well, I know, but tell me what you feel that you remember that'll always stand out, the most rewarding custody case that you had.
In my recent past, it would have to be the removal case that we had talked about. It was a long road. There were many nuances to it. And it ultimately had to go to trial. So it was nice to be able to get the result that the client was seeking after a full hearing.
What was the most disappointing case that you've had?
I wouldn't say that there's anyone
Well,
that
that's
was a
great.
particular
Wow, you're doing
disappointment.
good.
No, I like to, in probate court, the goal generally for me is always to resolve my cases.
Right.
So,
Well, it was such a pleasure to meet you. And, we look for demeanor and temperament, but what is right up there for me is empathy and compassion, and you had it. I mean, those 4 hours, I really appreciated you coming and meeting with you. So I'm not going to keep you. I'm thrilled that you came this far, and I said your father had to inspire you to do this and get here. So that's a
Absolutely.
wonderful legacy. So I'm very thrilled that you came, and I do want to apologize for this late fee. And I keep saying to my colleagues, one hearing a week. That's it. And I'm so sorry. Did you get to
quite
eat?
all right.
I hope.
Yes, we did. Thank you.
Okay. Well, thank you all for coming. And I really, you made my day. You
Oh,
really
thank you.
today. Thank you.
Yes, thank you for waiting. I know when we scheduled at 1 o'clock, we said it could be later, so I appreciate that. But I am a big advocate of great local lawyers becoming great local judges, and you're one of them. Big fan of yours, has been first presiding judge, the first district court judge to be named by the administration, Doug Dombrow, to become a presiding judge in the Commonwealth, and he's a huge fan of yours, and from day one. I respect and honor your dad and your uncle. Quick story: when I was a younger cop, patrolman, I got fired at in a bank robbery case. Okay, thanks. And your uncle tried the case. And at the end of the trial, the guy had done like 4 bank robberies, and your uncle talked about his guilt was as clear as the nose on his face. So he had like a Pinocchio nose, and it was a great line. So when Bob Juvenville talked about your uncle having these great one-liners in court and just taking the steam out of the room, he was great. So I miss him. Always respected him as an ADA when I was a young cop, and your dad did great service to the Commonwealth for a lot of years. So I was just going to close the hearing, but I'm told that Councilor Duff is right there. So Councilor Duff, welcome. Welcome back.
Thank you. Am I unmuted now?
You're unmuted. We can hear you loud and clear.
Oh, good, good, good. Some people probably wish I was still muted. I'm not going to ask you 2 questions. We had a great talk the other night. I guess one thing I did want to, and it's probably already been reviewed, but how often, I'm trying to think how to word it. I've seen instances where sometimes it's a woman, sometimes it's a man, but it often is a woman who they're divorced, and their husband has been the breadwinner, and they've been encouraged at the divorce proceedings to do things to better themselves or gain more education so they can make more money, and then they don't. And they come back after their partner for more money in alimony or child support. And it seems terribly unfair to me. Do you have any thoughts on that?
I would certainly consider in those situations attributing an income to the person, particularly if they have been encouraged to go out and seek work or seek further training to become employed in the workforce. I would
Okay.
consider that attribution of income.
Yeah, I find it incredibly disturbing, actually. I get, it never occurred to me to not be self-sufficient in some ways. And I know that sometimes there are circumstances where people cannot be. But circumstances where, there'll be a multifamily house. In fact, I'm a realtor. And in this case, where the wife, because wasn't working for reason, gave him the multifamily in the divorce settlement. And to me, that seems incredibly generous. That seems almost, I don't know, I find it disturbing. So, but that's really the only question. I talked about everything else with you in detail, and this has been a very, very long. So I will leave it at that. Thank you. Thank you, Mr. Chair.
Thank you, Counselor.
Thank you, Counselor Duff. Well, we're going to conclude the hearing, and congratulations from what I hear. I think you're going to be a judge pretty soon.
Thank you.
You'll know next week. Thank you.
Thank you.
Hearing's concluded.